So we have a very distinguished group to focus on our second, mostly domestic, but we could, I'm sure we're going to stray into the international as well. And that is to explore how the events of 9/11 and, of course, our policy response affected our laws. How did it affect in some ways, our interpretation of our founding document, the Constitution. And I really don't need to say any more because I have such great confidence in our panelists. We have Professor Silliman and Professor Madeline Morris from the law school and Robin Kirk from the Duke Human Rights Center. And their bios, of course, are in the readings. Before I begin, though, I just want to say that based on our last panel, there's a whole calendar that Mona Hassan has put out about events all fall about Islam in America. So anybody who wants to pick one of those up and attend the events, they are available to you. So I think we're going to, as we did last time, it worked very well. We'll go from left to right, or my left at least. And we'll start with Professor Silliman. And first, I just want to thank all three of you for coming, and I'm looking forward to a good discussion this morning.
Thank you, David. Let me suggest that when the airplanes hit the World Trade Center and the Pentagon almost 10 years ago, that President George Bush, shortly thereafter on two specific occasions, said that we were at war. And he invoked what many of us call the war paradigm to deal with terrorist threats as against the more traditional law enforcement mechanism of dealing with terrorism as a crime, which, by the way, I think, as most of you know, is the predominant view in European countries. Well, that declaration of war, both to the American people and in the State of the Union address on the 19th of September, basically caused a fundamental cultural shift with regard to the legal paradigm. It said to the law enforcement community, you should no longer be concerned with apprehending people after a crime. You should be more concerned with preventing acts of terrorism. And so that shift in law enforcement exists even today. More importantly, the Congress of the United States, in a number of different pieces of legislation, changed us in a way which we had never known before. In probably the largest piece of legislation, what's called the USA Patriot Act of October of 2001. And this act was not a long law written. It was a series of amendments to already existing legislation. But it made some fundamental changes in the way we deal with threats of terrorism and acts of terrorism, and also had an impact on what we would consider our traditional constitutional rights and civil liberties. One of the most striking had to deal with electronic surveillance. And it was a subtle change, but a huge change. Under pre-existing law, going all the way back to 1978, in order for there to be electronic surveillance of foreign powers or agents of foreign powers in the United States, then a specialized court that was created in Washington had to find that the purpose of that surveillance was the gathering of foreign intelligence. And most of the lawyers interpreted that as at least 51% of the purpose of the surveillance had to be foreign intelligence gathering rather than law enforcement. Well, Congress changed the words "the purpose" to "a significant purpose," which many interpreted as saying, well, if a U.S. attorney goes in and he says, I am really wanting to target David Schanzer, I believe he's an agent of a foreign power, and I want to prosecute him, as long as there was some degree of concern that there would be foreign intelligence gathering, then this court would approve the electronic surveillance of David Schanzer. And that's had a major effect as far as allowing much more electronic surveillance in this country. And again, a decrease in what you and I would consider to be our protection against unreasonable electronic surveillance. Another provision of this foreign intelligence, or the Patriot Act, had to do with roving wiretaps. Again, previously, if there was going to be an intercept of a cell phone that Robin was using, then a court had to specifically authorize the device or tap on the device she was using. The Patriot Act allowed for what we call roving wiretaps. In other words, it targets the person no matter what device that she's using, whether it be a cell phone, landline, email. And so this is all now authorized for the investigative community and the intelligence community to use. There is an administrative subpoena called a national security letter, again, authorized by the Patriot Act, whereby the Federal Bureau of Investigation, merely on the basis of an ongoing investigation, can go to any business that you deal with and seize any tangible items that relate to that investigation. This became known as the library provision, where supposedly the FBI could go into a library and seize books and record books that you checked out of the library. Now, to my knowledge, that never happened, but the law authorized that. So the Patriot Act caused all those changes. Airport security. Do you remember the days before 9/11? Now, what you can take on the airplane, how you are screened is fundamentally different. Now, I'm of the view that I don't agree with those who say that when you go through that scanner at Raleigh-Durham Airport, that's a violation of your constitutional right of privacy. I don't believe that. Many do. But nonetheless, that is much more of an infringement, at least on your ability to travel, than ever before. Interrogation, a very, very controversial subject. As most of you know, the Department of Justice and the Office of Legal Counsel interpreted existing domestic law and international law to say that interrogators for the CIA who were holding detainees in what were called black sites outside the United States could use very coercive techniques, and that the use of those techniques did not violate domestic or international law. Now, it's still a debate on whether the information that was acquired through those particular interviews actually saved lives or attacks. But at the very least, when you look back at the pictures of what was done at a prison at Abu Ghraib, that it did a great deal of damage to the image of the United States. So let me kind of sum up. The law has changed greatly since 9/11, and it is changed to facilitate both the intelligence community and the law enforcement community to prevent or to seek things that will prevent terrorist attacks. But at what cost? At what cost? Many argue that what has been done through changes in legislation and interpretation of existing laws has rubbed against the fabric of what the United States has always claimed to be a nation under the rule of law, and that we have gone so far and infringed upon your civil liberties and perhaps your constitutional rights that we have lost more than we've gained. That's a debate that is out there in the public, and a debate that I hope we can have here this morning.
Thank you.
Thank you very much, Scott. I'm glad you started that way, because I decided to focus my remarks on just one part of what Scott is covered in his remarks, which I always find to be very instructive and provocative. First, I just wanted to thank you, David, and thank the organizers of the conference for having me here. I really appreciate the opportunity to come and have this discussion. I think it's obviously very well timed, but I think one of the things that I'm going to comment on is that there's a lot of work, I think, that we as Americans need to still do to address what happened after 9/11 to the present day in terms of human rights. When I was thinking about what I was going to say, I was remembering what I was doing on September 11th. I actually remember it very clearly, because it was my first sort of slow day after spending several weeks working. At the time, I was a senior researcher with Human Rights Watch, working on the countries of Colombia and Peru. And I had been working with my colleagues, as well as people within the State Department, preparing a briefing book for Secretary of State Colin Powell, who was planning a trip to Peru and Colombia for September 10th and September 11th. And we had managed to convince his staff to include, as part of his outreach to the Colombian government, material on paramilitary groups that were at that time involved in major atrocities, often in coordination with the Colombian military. And our argument to the State Department was that these paramilitaries, who were also drug traffickers, should receive special attention from the United States, and potentially the United States should work out arrangements to extradite them to prison here on drug trafficking charges, but in a sense made more important by their involvement in human rights atrocities, and that was an important element in what the United States could do in terms of helping human rights in Colombia. The Colombian government at the time denied that the military was involved with paramilitary groups. The evidence was overwhelming, however. But the military would often justify what they would claim would be tacit support by claiming that they were fighting a new kind of war against an entrenched and brutal guerrilla insurgency, so work with paramilitaries was necessary. And I mention that little detail because I found, when I was last night listening to Juan Zarate give his comments, I heard him say something a little similar, which was that this was a new kind of war, and therefore exceptional methods were required in order to combat al-Qaeda. And I think that, from a human rights perspective, is both a very familiar assertion and a very dangerous one. It's something that is very common among even democracies when they're facing terrorist attacks or terrorist groups or guerrilla groups. But I think it almost inevitably leads down a very bad path. Colin Powell never reached Bogota because he gave his speech before the Congress in Lima, and then September 11th happened, and he was rerouted back to Washington. And I think from a human rights perspective, as someone who worked in human rights, everything changed from September 11th from September 10th to September 11th. And my boss at the time, Ken Roth, I think said it very well in the days after 9/11 when he said that the U.S. went from being the leading governmental defender of human rights around the world to the country leading new and ultimately destructive ways of abusing human rights, inspiring violators around the globe. As an Americanist, I should qualify that by saying I'm not at all wiping out or ignoring the history that the United States has in places like Vietnam, supporting regimes like Pinochet's in Chile, the torture instruction that we did in the Americas in the 1960s and 70s, not at all. But I think by the late 1990s, you had no better governmental friend for human rights protection than the United States if you were doing human rights advocacy work, and that was equal for both Democratic and Republican administrations. This was nonpartisan support for human rights. But we lost that on September 11th. I want to emphasize that I condemn absolutely the attacks on September 11th. There's no other way to approach them. They were heinous, illegal, and evil. In the worst of cases, I think terrorism, one of the aims of terrorism is to goad the larger and more powerful force, including democracies, into overreaction, into vengeance, which results often in further atrocity and bad policy. And I think we adopted very bad policies in the wake of 9/11, in effect amplifying the effect of this terrorist attack, causing additional unnecessary suffering and benefiting those who were willing to apply ever more extreme tactics. As I mentioned, I did want to comment on Juan's assertion that this was a new kind of war. I don't think it was a new kind of war at all. It was certainly exceptional because it took place in the United States, exceptional because it was a large number of victims. But I think any historian would certainly agree that al-Qaeda, as in the terms of its tactics or in terms of its focus, is neither new nor particularly unique. Democracies have faced terrorist acts for decades, just post-World War II. We can talk about Colombia, the country that I worked on for a long time, the United Kingdom with the IRA in Northern Ireland. It's too bad that our Northern Irish person has left at this point. Spain, just to name a few. I wanted to focus specifically on the issue of torture in the context of 9/11. And I want to just keep my comments brief, so I just decided just to say a couple of things about torture. I think another thing that Juan said yesterday, which I would take exception to, is that there have been alleged incidents of torture. There's nothing alleged about the torture that has taken place in the context of 9/11. There's tons of evidence. There's absolutely no question that the United States engaged in torture of suspects in the war on terror. He actually mentioned specifically the case of waterboarding, and that said that there were only 3 cases of waterboarding that occurred in the context of the war on terror. That's just flat out wrong. But I also want to say that waterboarding is only one of a very diverse kinds of torture that have taken place in the context of 9/11. It certainly got a lot of attention, but it is by no means the most egregious and is by no means the most common form of torture that committed by U.S. forces or proxies of U.S. forces. Within the category of human rights, there's no more absolute ban than the ban on torture. You cannot be tortured even if you're guilty, guilty, guilty. There is no excuse and no loophole for torture in human rights law. When I say torture, I should probably identify exactly what I mean. Obviously waterboarding, which is it's not simulated drowning, it is drowning someone to the point of death. Beatings, rape, electric shocks, stress positions, extremes of cold or heat, all of this happened in the context of the U.S. war. All of this was practiced by U.S. officials and their proxies. Again, thickly and extensively documented. But that is not the only kind of torture, and I wanted to take a second to comment on psychological torture, which was a big part of how we abuse people in the context of the war on terror. By far, much more than actual physical torture, psychological torture is extremely damaging to the people on whom it's practiced. But psychological torture was practiced routinely in places like Bagram Air Base in Afghanistan, Guantanamo in Cuba. And I think Scott mentioned early on that the Bush administration actually explicitly approved elements of psychological torture in the memo that Donald Rumsfeld signed in December of 2002. Stress positions, hooding, deprivation of light and sound, the use of dogs and other phobias on detainees, and all, if I'm not mistaken, prohibited in the Army Field Manual of the time. There was a big gap in between what the Defense Department was saying and what the Army actually teaches its interrogators to do. And I would just say that that psychological torture in particular actually came out of a lot of university-based research in the 1960s. Historian Alfred McCoy has written a very good book called A Question of Torture, where he details how this came about and how the CIA in particular supported and used research done by behavioral scientists on effective uses of torture. It destroys the mind. It's extremely difficult to recover from, and it leaves the victim literally undone, often unable to overcome the trauma, even after years of rehabilitation and care. I'll just mention one case, one of the more famous cases of an individual who was tortured in the context of the war on terror, and that's Khaled al-Masri, who is a German citizen, a grocery store owner, who was traveling in Macedonia when he was detained by the Macedonian officials at a border checkpoint because his name was very similar to the name of a well-known al-Qaeda operative. The Macedonian authorities contacted the CIA, said they had a potential terrorist in their custody, and what the CIA told them to do was release him so that they could grab him. And they sent a CIA snatch team into Macedonia to grab him. They stripped him, beat him, drugged him, gave him an enema, put him in a diaper and a jumpsuit, flew him to Bagram, and then took him to a place called the Salt Pit, which is one of the dark sites or the black sites that Scott mentioned. He was there over 6 months, kept him in a squalid cell, gave him meager rations, putrid water, and tortured him, raped him. These are American soldiers. After about 6 months, people realized that he was in fact not the al-Qaeda operative. He was a German greengrocer. And actually CIA Director George Tenet and National Security Advisor Condoleezza Rice ordered his release. This is the important part. I mean, all that stuff is bad. But here's what they did. Knowing that they had an innocent man who had been tortured, the CIA flew him out of Afghanistan and dumped him on a road in Albania without his wallet, without his passport, without his shoes. The Albanian police thought he was a homeless guy. They didn't know what to do with him. And then finally, he was able to make it back to Germany, and that case is going through the German courts at this moment. He has tried to bring his case into the United States, but it has been denied under the State Secrets Act. I will just say that the planes that flew this poor gentleman around Europe are based here in North Carolina. They fly out of Smithfield. They're part of the CIA contracting company called Aero Contractors, so there is a hometown connection to Khaled's case. Another person who just made it into the news recently is Abdel Hakim Belhaj, who was also the victim of extraordinary rendition, tortured in a CIA black site. He is now the leader of the rebel Libyan military forces in Tripoli, and is claiming that both the M16 and the CIA were responsible for his illegal detention. Both he and Khaled, innocent people. I want to address another question that was raised by Juan's remarks yesterday, and then I'll finish. Juan suggested that the torture was limited to a very brief period of time, which again I think is flat wrong, but that also this was part of a phase of adaptation that was then left behind by design. And that it was and that the assumption being that it was necessary. I absolutely disagree. And I disagree both because I believe torture is wrong, it's illegal, but it is also not effective. And I would say that it does not, it's more than just damaging to our image, I would say. It is damaging to our security. I'll give you one example of the kind of information that the U.S. did obtain under torture and how it was used, and that's the case of a known al-Qaeda operative, Ibn al-Sheikh al-Libi. Under torture, he said that Saddam Hussein trained al-Qaeda members in the use of weapons of mass destruction. Flat out wrong. But this information was later put into Colin Powell's speech, the now discredited speech before the United Nations. And it was, as I say, completely false. People give all sorts of information under torture, and I will be the first one to say that sometimes torture works. The problem is you don't know when. You just don't know when. It also complicates enormously any sort of possibility of trial, because it is illegal to use information gained under torture in the course of a trial, and that certainly has been one of the elements really making the trial of Khaled Sheikh Mohammed extremely difficult. I'll just conclude by saying this. We know a lot about these cases by the people who survived them. People like Khaled al-Masri, people like Maher Arar, who was Canadian, also tortured, rendered to Syria. We know a lot about cases like Binyam Mohammed, who was recently, or within a year ago, released, a British national who's also underwent torture. But we don't know enough yet to really know the full extent of the criminality that took place in the context of the war on terror. Unfortunately, our leaders, including President Obama, have prevented us from gaining justice for the victims, for their inability to bring these cases to U.S. courts. And we don't have the full and detailed story yet of how this happened, who ordered it, and how the chain of command really worked. There's a ton of information that's still classified. Some information has been released. It's been heavily redacted. And I think that we really need to know the story of why this was done and need to know who is responsible. I just finished a trip to Chile, and I wanted just to note that on September 11th, we're also facing another anniversary, which is of the coup in 1973 in Chile. And interestingly, this year in Chile, the human rights groups can report that 95% of the Chilean police and military officers who are implicated in killings, torture, and disappearance have been or are the subject of criminal trials. 95%. And I think that that is an essential point for democracy to get to when it can provide accountability and it can tell the true story of what happened in a, at the very least, misguided attempt to protect against terrorism. And I think that justice is something that still remains something for the future for us to do. But thanks very much.
Are these all on?
I think so, yeah.
I think that the most pervasive or thoroughgoing legal change that's come out of the 10 years since September 11th of '01 has to do with destabilization of law, more even than anything that I would call change in law. I think we're very much on lots of different legal fronts in a state of flux, and the dust still hasn't settled. In fact, most of the dust, as it were, hasn't even been really identified or articulated. A lot of the content of law has become indeterminate. It's not clear what the law is anymore in areas where we thought we knew what the law was. For example, who can be detained in a wartime situation, or how do we define a wartime situation? So it's not, in those broad sorts of questions, it's not so much what legal changes can we identify so much as that there's a lot of legal space now that's unoccupied or undefined. We were confronted in 2001 with a threat that we understood very little about in terms of its magnitude, its nature, its source, and its trajectory. And picking up on what Robin was saying about the familiar refrain of this is a new kind of war and the danger of what that generally leads to, I'd want to qualify that or focus on that further by saying there are two dangers there, I think. One is the free-for-all of this is a new kind of war, everything has changed. And on the other hand, in reaction to that or in avoidance of the deleterious effects that can follow from that move, there's also a danger in asserting that nothing has changed when some things are different, when some features of a new situation are different from the features of the situation as they existed before. And the results of either move, everything has changed or nothing has changed, are inevitably similar. That is, both lead to lawless conduct, either on the one hand because it's a free-for-all, everything's changed, none of the old rules apply, or on the other hand, by lying to ourselves and saying everything that we had before still works well, and knowing that it doesn't, inevitably then circumventing existing law rather than developing law in response to new features of a situation. I think that we've been, for 10 years, paralyzed in large part on the horns of that dilemma, to mix my metaphors. The result has been large vacuous areas in law and shifts in power, largely to the executive very visibly, but somewhat less visibly also to the judiciary, as we've avoided legislating a lot of what we do because we don't particularly want to confront and sort out what's new, what isn't, what's called for, and it certainly isn't in the electoral interests of anyone to take on a lot of those issues. So we've been left with areas where we don't know what the law is. And that's true both in domestic law and in international law as well. The most obvious question in terms of even categories of law arises with regard to the war versus crime question. So there's questions about specific answers to specific legal questions, but there are also still very much unresolved questions about what bodies of law are we even to bring to bear to answer the legal questions that arise. The most obvious and the one that emerged most immediately was the question, are we talking about war or are we talking about crime? Or are we talking about some combination of those? What body of law should we even bring to bear in responding to the situation, the potential defendants / combatants? How should we think or talk about the legal questions that arise? And of course, it matters, right? It matters in terms of interrogation, for example. Is a particular subject of an interrogation entitled to Miranda rights in the context of that particular interrogation? Or what's the basis for a person's detention? Is it pursuant to a criminal prosecution? Is it a law of war detention without criminal prosecution? And if it's a law of war detention, why then nevertheless prosecute in, for example, a military commission? What's the purpose of that prosecution when it's detached from the basis for detention? Remarkably enough, all of these questions remain unanswered and even unclarified, certainly unanalyzed as to what exactly are the purposes we're pursuing with regard to detention, prosecution, how do these work together? We're winging it, which is what we have typically done in other, quote, wartime, unquote, situations, but in this situation, we're less able to do our usual process of taking steps that we can later express regret for or renounce or say that was an aberration. Most wars in the past have been identifiable, and their ends have been identifiable and predictable, and so we've been able to muddle along reasonably well with this system of doing what we have to do and then saying afterwards that perhaps that isn't what we should have done. Here, we proceed in that way at our peril. I think that we've proceeded in the ways that we have in the past in a situation which is changed in one way, in the respect that this is not a war that we can easily identify the location of or, very importantly, the end of. How would we even know if this war or rash of crime or whatever we call it, how would we even know when to say, okay, that period is over? So because of all of that, I think that the move that has been available to us in the past of muddling along, of not concretizing the whatever exceptional steps are viewed as necessary, if any are, is not really available to us in this instance. We're doing it, I think, because we haven't really confronted the fact that not everything has changed, but not nothing also has changed, and have not sorted out, well, what are the features that are distinctly different? What do they call for? Why? We just, remarkably enough, have made fairly little progress in confronting and in analyzing and in choosing, rather than moving along by some version of evasion and default. The questions that remain unanswered and largely unqualified and unanalyzed and undefined exist in domestic law, certainly very much so also in international law. For example, with regard to the right of self-defense, Article 51 of the UN Charter states that all states have an inherent right to defend themselves against attack. But we've made very little progress in asking ourselves, or in answering, much less in answering the question, what does that mean in the context where a state is attacked by a private entity as opposed to another state? The Security Council, in the days following 9/11, issued 2 resolutions, each reiterating this right of self-defense in response to an attack by a private entity, but neither of the resolutions addressed what exactly that means in this context, and most particularly neither resolution addressed the question, what about the territorial sovereignty of the state from which that private entity is operating? It's fairly straightforward if one state attacks another state to say, okay, we will respond by using force on the territory of the attacking state. But what about when the state where the attack emanates from didn't do anything as a state? It was a private entity acting from there. What do the Security Council resolutions mean when they say you have a right to use self-defense? Does that mean a state attacked by a private entity has the right to use force on the territory of another state? And what happens to the territorial sovereignty and attendant rights of that state, the so-called host state? Remarkably enough, we don't know. Because the Taliban was involved with al-Qaeda to the extent that it was, it smoothed the way initially towards justifying an attack within Afghanistan, and that has sort of blurred the more stark question, what about the territorial state? What does the right of self-defense mean in this context, and how do you reconcile those fundamental features of international law? We've gotten virtually nowhere on those questions, remarkably enough. At the same time, as the Security Council reiterated the right of self-defense, saying nothing about territorial sovereignty in that context, in 2004, and then again in 2005, the International Court of Justice issued opinions suggesting that the right of self-defense is not applicable in response to attacks by private actors. Entirely inconsistent with Security Council resolutions and with state practice after 2001, but nevertheless, the International Court of Justice has those opinions out there. And what is the international law on the question of whether the right of self-defense applies to defense against attacks by private actors? Great indeterminacy, ongoing, and for various reasons, and you can look at different constituencies and actors, no one particular group or authority or power base in a position to respond to these questions has found it to be in their interests, or sufficiently in their interests, to do so. Even more broadly, in terms of destabilization of basic legal paradigms and structures, question, what is the current status of the peace and security framework under the UN Charter, where the Security Council under the Charter is presumed to be and is established as the principal guarantor of international peace and security? How does that work where the Security Council has no leverage over a private entity in the way that it would have leverage with the state, and indeed has no legal relationship with a private entity? So then, how does the framework for international peace and security exist and go forward? What's the system where you have major threats involving private entities? Also unanswered, undealt with. Law of war, similarly, very much destabilized, but certainly nowhere near restabilized. The basic categories of law of war, categories of people, civilians, combatants, detainees, internees, all categories that we can no longer apply with any certainty as to their meaning, their appropriate application, either in terms of definition, how do you define a combatant, or in terms of identification, how do you know whether this person fits whatever definition you would apply? All of that, again, is, I wouldn't even say in flux, it's sort of in suspension. We haven't moved forward in designing definitions and systems that will allow some realistic address to the current situation under a rule of law, on a rule of law basis, because we haven't said maybe we need to design new law for the particular features of a new situation that are new, guided by existing law and applying existing law for those features of the situation that are not new. The destabilization in all of these and other areas has, of course, resulted in power shifts. If there's less law that applies, you're likely to have more power, obviously, in the executive branch. Less visibly, as I started out by saying, more power has gone to the judiciary. The judiciary currently is the main, not only articulator, but in fact designer of the law that would govern and limit executive power to detain, to interrogate, to choose between prosecution and non-prosecution, and to choose forums for prosecution. A lot of that is governed now primarily and in some instances virtually exclusively by judicial pronouncement for lack of other source of law. I don't see progress towards re-legalizing a lot of these questions or a lot of this area of practice, again, because if you look at if you look at Congress or if you look at non-governmental organizations, in each instance, there isn't sufficient impetus to seek to concretize law, either because of electoral politics or because there's a preference not to concretize exceptional measures in hopes that it'll all go away. I think that we proceed in that way at our peril and at the peril of rule of law in the longer term.
Thank you, Madeline. That was really excellent. Professor Silliman, I know I saw you sketching some notes. You had a chance to go first, so did you want to make any specific rejoinders to some of the things that were said afterwards?
Well, I just want to respond to a couple of things that Robin indicated with regard to alleged violation of human rights. We have the two paradigms that we've discussed. We have the war paradigm that Juan talked about last night. I mentioned it. I think Professor Morris has mentioned it. And then you've got basically the human rights paradigm. And when you're at a time of peace, then the two are not necessarily in tension. But you're in a situation post 9/11, which I think all of us have tried to describe, but I totally agree with Professor Morris. There's a destabilization of the law. There are uncertainties as far as what the law is, and if there is law, how do you interpret it, either domestic or international. When we're in this type of situation, there is a tension between human rights law and what we call international humanitarian law, law of war, law of armed conflict. And it has always been the United States' position that the law of armed conflict will trump human rights law. Now, that's not to suggest that there's a sanctioning of human rights violations, but it is to suggest that there is a different perception of allowable conduct in response to attack. And that is exactly how the Bush administration responded initially. And when we talk about the interrogations that were done at the CIA black sites, I don't want us to come away from this morning suggesting that you had a bunch of rogue CIA agents or military members that were just at will doing anything they wanted to. We've got to understand that the Department of Justice, including the Office of Legal Counsel, is charged with giving the Executive Department legal advice, which is dispositive. And I think Robin mentioned the Secretary of Defense memo with regard to what would be allowed at Guantanamo Bay. We also should know that the military attorneys, the JAGs, were fiercely railing against that by suggesting that the traditional military view has always been to use interrogation techniques that were Geneva compliant. So you had different agencies within the federal government arguing over what the law was, I think, which goes to Professor Morris's point. And again, there have been court challenges, El Masri, Jefferson Data Plan, Ninth Circuit, where at least the judiciary has said there are some things that the United States does in the name of national security, some programs, which should not be the subject of litigation. And you're very correct that those cases were shut down under the state secret privilege. That's not necessarily a good result, but that's how the judiciary is looking at some of these things. As Professor Morris suggested, the law on who can be detained and for how long is basically being hammered out in the District of Columbia Circuit. That's where all these cases are, and the judges are taking different positions. I am aware of the fact that there is an amendment proposed by John McCain in the current Senate version of the 2012 National Defense Authorization Act, which would in fact create in statute and give definition in statute what it is to detain, who may be detained. That provision also calls for any terrorist who is arrested to immediately be turned over to military control, which is a very large change would be a very big change in existing law. So I agree with both my co-panelists that we are going ahead in almost an ad hoc manner. But I don't want to fault that too much, because at least we are trying to move ahead. All the branches of the government, the executive branch, Obama administration is following through, and there is a continuing extraordinary rendition program by executive order under the Obama administration. It's meant to be done humanely, but to suggest that the Obama administration has abandoned all these tools of war that the Bush administration used is wrong. So we are moving forward. I think we're seeking clarity. It is not easy to understand, nor will it necessarily be right in the long run. I think only history will be able to judge whether our use of military commissions, our interrogation techniques were right, or, as I said earlier, whether they have done severe damage to the fabric of what it means to be an American.
Thank you. If I might pose a question to our panel on this question of accountability, because I think it's one that is an important one, and certainly one the current administration has struggled with and also been subject to some criticism over. On the one hand, you can say, as Professor Silliman argued, that lots of the activities which Robin laid out were reams of memos from the Justice Department going and documenting and giving instructions to the individuals. And then there was recently a referral to a special prosecutor to try to look for any instances that went beyond those instructions. And the Justice Department was ready, it seems, to authorize a prosecution if they found instances which went beyond those instructions. And I think other than, is it one exception, they didn't find any. And that might be a case that's going to go forward. So that's a reason for these individuals maybe to not be held accountable in the same way that Robin discussed. But then on the other hand, you do have this, the policymakers then, the people who wrote the memos have been not held accountable in a very strong way. So if we shift blame in some ways for things that might have gone wrong to those who interpreted the law, those who were the policymakers, so what should we have? What should we do on accountability? Are we right to move on, as the Obama administration said, or do we have to? Does the rule of law and our sense of justice require us at least to look backwards to some degree at this chapter? Anyone want to take a crack?
Yeah, I'm not sure it's responsive. I'm not sure it's an answer, but one of the dangers, and a very serious danger, of not articulating clearly law, and I hesitate before I say law, because what we're really not doing is we're not articulating the depth of the dilemma that we confront. And refusing to articulate and confront that, we then certainly don't make explicit law to govern what we're going to do in response to this dilemma. So by muddling along and not confronting clearly the choices we need to make and then not making them in law, we're then left with the problem of this ambiguity about who's responsible for what.
But on torture, we had an international treaty, we had a domestic statute. It's not like there was a total absence of law on that issue. There was interpretations that were then made, but that always happens with law.
Yeah, and the Office of Legal Counsel's interpretations are understood to be dispositive for the executive, for purposes of the executive branch, yet and when you say hold accountable the people who wrote the memos, well, accountable for what? If the memos were written, the memos that were written by Bybee, by John Yoo, Jim Haynes' participation, all that, were written, in my view, and I know the people and I talked with them about it, in good faith. They were not saying, ha, 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 here's my opportunity to direct illegal torture. So where that's the case, where the facts are unclear and where the question is one of legal interpretation, I'm not sure that the most important lesson for us to take from it is one about accountability for the interpretations that were made, as much as one about the need to be prepared for future 9/11s with law in place that's actually workable and actually responsive and actually clear, so that at that point it's fair to say you need to be held accountable because you did something wrong and that should have been clear to you at the time. Instead, we've spent a lot of time looking at who should or shouldn't be blamed while not taking the responsibility for saying, what do we do next time? What's the law the second time? First time, okay, we didn't expect that. Now we know very well what the possibilities are, and we still don't have law in place. That, it seems to me, is what somebody should be held accountable for, in particular, and more urgently even than the question of accountability for transgressions that may have happened.
Robin, do you want to take a crack at that?
Yeah, I mean, I think, I do think that there's a level of accountability that's not only necessary, but is going to be inevitable. I mean, there's kind of a rule of thumb within the human rights community that takes about 20 years to get there. So we're only about halfway. And other countries that have had serious human rights issues, that have passed amnesty laws or punto final in Argentina, whatever, it's taken them about 20 years to go back and look at the legal situation and then begin to prosecute. But to get there, we have to be building, and I agree with Madeline on this, we have to be building that legal structure to allow us to get there. And we're not going to do it by blocking these cases, by blocking cases that involve individuals who've been tortured from our court system. And I think that if I could use a rough parallel, and apologies to the lawyers, if we look at the death penalty in North Carolina, where we've had or even just criminal justice. We've had case after case of innocent people who've been convicted and in the worst instances, sentenced to death. And the only way that we've been able to address the problems within the system that allow that is through litigation, is through defense lawyers, is through appeals, and then through reforms that are then implemented to correct the system, to build the precedents, to build the law that allows us now, for instance, to have defense lawyers have access to the full discovery in death penalty cases, to be able to have an innocence commission that reviews cases. We don't have that right now for what's happened in the context of the war on terror, in large part because we're blocking investigations, because we're not examining the real record of what happened. And I think that the absence of information that can lay out who's responsible for what, when, how, makes accountability extremely different. And we need that from the Obama administration, from future administrations. And I think that, there's a suggestion that, I take the point about the memo being written by the Justice Department, but I think there's at least a certain body of evidence that suggests, and I think Scott underscored this in his comment, there was this huge discussion about what was legal, and you had for the most part, the military, actively and aggressively and determinedly arguing against this as a violation of our commitments under the Geneva Conventions. It wasn't a mystery that this stuff was going beyond the bounds of what should be acceptable behavior. And I think if you look at, the experts are here, so I'm not going to get too far out on a limb here, but if you look at the way human rights law has been interpreted, there is a body of law about due obedience and about whether or not military or state officers, state security officers, should know that the orders that they are being given are violations. And I think that there's a, I'm not saying that should be the conclusion. I'm saying that we should be investigating. We should be opening this to inquiry so that we can then build the kind of law that Madeline is suggesting to allow us. I mean, I am concerned. I remember Abdullah knocking the table here. I'm concerned about the next 9/11. I agree, we don't have the law in place and we don't have the understandings in place that are going to prevent us from going back to what the Vice President called the dark side. I'm concerned about that.
Okay, well, let's open it up to folks in the audience who might have questions. Jenny has a mic, if we have any. Right here.
You haven't. Hi, is it on?
That's better. Good, thank you.
Yeah. No one has mentioned the use of military commissions versus civilian trials, and that's certainly a big change.
I'll defer to my colleague to my left who's an expert in that area.
Well, military commissions have a historical basis. Military commissions were used in World War II. By statute now, the Congress of the United States has basically said that no one currently at Guantanamo Bay, there's no funding to bring them into the United States for federal trial. So in effect, this means that Khalid Sheikh Mohammed and the other four, and many others at Guantanamo Bay, will face military commissions. They have been criticized. And certainly the first iteration of military commissions created by President Bush in November 13th of 2001 had a paucity of due process. I would suggest to you that in my reading of not only the 2006 Military Commissions Act, but more recently the 2009 Military Commissions Act, that it comes within about 90 to 95% of the same due process afforded in the court-martial system. So I am a defender of military commissions as a forum for the prosecution of certain types of individuals, not United States citizens, certain types of individuals. I believe we will have to wait to see how they play out. But the Congress has worked, I think, greatly to improve the amount of due process in military commissions, and that there should be trials in the federal courts of some types of folks like Giuliani and others who were brought into the United States. But I think military commissions have a value to dealing with those particularly at Guantanamo Bay who were captured overseas. But I want to defer to Professor Morris because I know she is more than I am an expert in military commissions.
But the one point that goes to the initial talk you had, though, what we don't have is a rule of law, or even really even a very well-articulated policy of which cases have to go to military commissions and which may go to a civilian court. And that's, of course, really made clear by the Warsami issue, which is this individual who was essentially detained under law of war authority on a boat, captured in Somalia, and then stayed on a boat for 2 months. So there's the war paradigm. And then as soon as the boat gets to New York Harbor, he steps off and gets arrested and goes off to civilian court, and there's the crime paradigm. So anybody who's suggesting that we have made any sort of decision as to which paradigm works can have to look at this case. But anyway, please.
But it's the Warsami case that you're referring to, which prompted Senator McCain to put that amendment to the authorization bill. So, but you're correct. Right now, the administration is picking and choosing, and there doesn't seem to be any policy. There was a memo, as you know, that set out the criteria for which cases would go to military commission and which federal courts. My reading of that memo is it's very ambiguous and it's not definitive. But, Madeline?
My question would be, what is the purpose of military commissions? Where you have, particularly where you have somebody who's going to be detained without regard to the outcome, including an acquittal, they will continue to be detained, as has been made clear to be the policy not only under the Bush administration but under the Obama administration, that there are certain people who may be subjected to trial by military commission or even in federal court, but in any case would be detained even in case of acquittal. So the question is then, what is the purpose of that prosecution? And I don't ask it rhetorically to suggest that there's no purpose, but rather to suggest that we should be very explicit about what the purposes are. And I think that we are precisely the opposite. We're completely muddled, and I dare say that the administration is completely muddled, both in the sense that for many individuals acting within the administration, they don't have an answer even for themselves on that. Also muddled in the sense that across people within the administration, they'll disagree on the answer to the question, what is the purpose of these prosecutions? And if we don't have a policy, a theory, a process of reasoning about why we are even conducting certain prosecutions, then the question which the appropriate forum would be is not likely to come up with a very coherent answer. And I think we're at that absolutely elementary
So
step.
for those who are not experts in this field, I think what if I could just bring it back to basics, is that we are saying, specifically with the people in Guantanamo, and maybe future alien detainees, is that they're being held till the end of hostilities under the law of war, which does not require, our theory is, does not require any sort of prosecution in a criminal court or a military commission. So in some ways, since we can detain them indefinitely as long as we want anyway, why bother? And once we're going then into a more criminal mode, are we discounting the justification for having to detain them or detaining them initially as law of war detainees? What is the value of that? And if we're not willing to essentially then release them after a potential acquittal, what is the value of going through some sort of prosecution as well? Do you have an answer to that?
And I totally agree with Professor Morris that we claim under the existing law of war, as we're interpreting it, that we can hold those folks at Guantanamo Bay until the termination of hostilities. Way back in Vietnam, the American government took the position that as far as the Hanoi Hilton detainees, they could be kept until the termination of the war. But you mentioned earlier that was a definitive date. We don't know when the end of this war will be. I think the justification for military commissions is that when you look at those at Guantanamo Bay, there are clearly those that are members of al-Qaeda or have supported members of al-Qaeda, but there is no evidence that could be used in a court of law, civilian or military commission, of a crime that was done. And yet, with regard to Khalid Sheikh Mohammed and others there is usable evidence that can be used. And the government's taken the position is where there is evidence of a war crime or one of the 25 different crimes listed in the Military Commissions Act, that the government will go forward with a prosecution. The dilemma is, as I think Professor Morris says, and you acknowledge, that if they are acquitted for whatever reason, then the United States government still maintains that they can be held. And that raises the fundamental question of why prosecute them if you can hold them. What's the justification? Well, the justification is you can also impose the death penalty under military commissions. So going back to your question, I believe there's utility in the use of military commissions, but I totally agree with the criticism that there is a muddled decision-making and continues to be until the Congress gives us greater guidance on it. It should not be left to the courts to do this. It should be a function of the legislative branch, and so far they have not been able to do that.
Can I say something further on
Well,
that?
can we, maybe
Absolutely.
we can get another question in. Do we have other questions? Oh, please, yeah.
If I can help you to a question about accountability and specifically directed toward Mrs. Kirk. You compared the situation in Chile in 1973 to the United States.
Why don't you speak into the microphone so people who are listening on the internet can hear you?
To the United States participation in the war on terror, and you seem to laud a 95% prosecution rate for those who participated in the situation in Chile in 1973. So would that be, in your view, a 20-year, you mentioned the 20-year resolution target as well. Would that be a target to have 95% prosecution rate for U.S. servicemen or CIA operatives within 20 years who participated in the war on terror and had contact with either suspected or actual al-Qaeda detainees and did things such as put them in stress positions, which you define as torture, or subjected them to extremes of heat and cold, also under your definition of torture. Is that your answer to accountability?
No, I didn't mean to suggest that 20 years is any kind of a target. I meant to say it's more of an observation that when countries have gone through intense political violence, it generally takes about 20 years to get around to accountability. And this is not, it's not at all scientific, but you see that currently in Chile and Argentina, which are pursuing prosecutions, and not of every person who took part, but of leadership. In Argentina, the generals who were part of the junta. In Chile, it was the top-level army officers who were engaged in disappearance and torture and executions. So it's not at all a way of saying that every person who took part in our anti-terror efforts would be prosecuted, not at all. But I do think that there's an open question about the people that planned and ordered activities that were clearly in violations of our commitments under international humanitarian and international human rights law. But not at all, I mean, I think in a similar way, in Northern Ireland at this point in time, even though there was a peace agreement and an agreement to reduce the sentences of individuals who had been involved in acts of violence during the Troubles, there's also what's called a historical inquiries team that is now working on cases that were not investigated at the time of the peace accords, and some of those cases are being brought for prosecution. In fact, there's a trial going on right now called the Supergrass trial, which is involving former IRA militants, which is causing a bit of trouble in Belfast these past couple of days, because it's targeting former paramilitaries and former British government officials who took part in killings and bombings against within the province of Northern Ireland. So it's not at all a target, and I'm not advocating wholesale prosecutions, but I do think that accountability has to be on the table for the people who directed and who designed the policies that led to massive human rights violations.
Can I just add something? To say that we should look back and criminally prosecute these people is one thing. To actually do it is quite a much more difficult thing. And that's because when you look at the complexity of the law, in my judgment, it would be exceedingly difficult to successfully prosecute anyone other than that perhaps one individual who exceeded the OLC guidance. And there's a reason for that. One, we talk about torture. And we all think we know what torture is. Well, in law, it's not that clear. There is torture, and there's another group of another type of coercion called cruel, inhuman, and degrading treatment. And Senator John McCain, on the 30th of December of 2005, in the Detainee Treatment Act, said the United States should not engage in cruel, inhuman, and degrading treatment. But it was a statement of policy. And so if you look at that and say, well, how do you prosecute someone who violates this statement of policy? You have to look to some criminal law. The only existing criminal law was the War Crimes Act of 1996, which Congress amended to change the definition of cruel, inhuman, and degrading treatment and put it at a much higher level. Further, the Detainee Treatment Act itself says, guess what? If you've got a CIA agent who is being prosecuted, it is a statutory defense to him that he relied on legal advice of counsel. Well, what's legal advice? The Office of Legal Counsel memo. So when the Obama administration made the decision to say, we're not going to look back, we're going to look forward, we're going to try to put in place things that will prevent this from ever happening again, there was a good legal reason besides a policy reason for them doing it, because I think there would have been virtually no success in trying to prosecute those folks.
If I could just add just a quick thing. I should probably have defined my terms a little bit more, but when I say accountability, I mean certainly the judicial side of it is one kind of accountability, but there are several other tools that human rights defenders are using, and one of them one is a truth commission, which would allow you to tell the truth, to bring evidence. We had one in Greensboro, the South African Truth and Reconciliation Commission. This is a well-known, not alternative, but it is another way of getting at why things happened. But most importantly, I mean, I think knowing about the past is important, but it's not important in and of itself. It's important because you can then figure out what needs to be done in terms of the law, in terms of judicial or legal responsibility, what have you, what needs to be done to make sure it doesn't happen again. And if we just close the door on the past and move on without that essential looking back to find out how we can make our system better, I think we risk doing it all over again.
Professor Fever will have the last question, I think, for this panel.
Thank you. A question for you, Robin. Do you sense in the human rights community any concern about the dramatic ramp-up of drone strikes in the last couple of years, including targeting, allegedly targeting American Alaki, and so is that going to be the next issue of the next 5 years? And if so, do you think there'll be calls for accountability of the political leaders who've authorized this drone campaign?
I think that there certainly is concern about how, not about the fact of drones. I think it's another weapon, and with any kind of weapon you have to ask how is it being used, under what circumstances, or what sort of parameters in terms of international humanitarian law, what it's being. So drones in and of themselves are not any more human rights violations than any other weapon. I think it's the question is how are they used, under what circumstances? And I think there certainly will be discussion within the human rights community about that. And about the when they're used in a way that violates proportionality or that causes civilian casualties in certain ways. But I don't think it certainly won't be the kind of an issue that is as galvanizing as torture and fair trial and extraordinary rendition and things like that. I think these are more on the forefront of the human rights concerns at this point in time.
One thing on drones. We killed an American in 2002 in Yemen. It was in accordance with the rules of proportionality, but the theory is that even an American who takes up arms or is at war against the United States is a lawful target under the war paradigm. I have no problem with that. If you make sure that your collateral damage, injury to innocent civilians or civilian property is minimized and it's not excessive to the military advantage to be gained, that's international law rule, then why should you not be able to kill an individual who is the enemy with a drone when you could kill him on the battlefield in some other way? I understand the concern and the emotion of saying, well, we can even kill an American, but there have been Americans that have fought against the United States in the past that have been killed, and it's totally legal.
How about the sovereignty question, though? Where's the battlefield? Can that be done anywhere?
Well, that is the issue, and the United States position, as expressed by Harold Koh, the legal advisor of the State Department, is that when you have a country like Pakistan that is unable or unwilling to deal with a threat to the United States within its borders, then we are justified in using force within Pakistan. Now, you may agree or disagree with that, but that's the current United States interpretation of international law and why we are therefore not violating Article 2-4 of the UN Charter.
Madeline, did you want to get a last word on this issue? Or?
The concern, I think, with drones is if you're on a traditional battlefield, you have a pretty good way of ascertaining who the enemy is and whether a particular individual falls within that category. Where you've identified a particular individual not on a battlefield, then the question of identification and evidence becomes much more problematic.
But that really brings us back to our initial question is, what did 9/11 change? And we don't know if we're going to have wars that look like World War II anymore or in this century, that our wars, our conflicts, whatever you want to call them, are at the moment not as clearly demarcated. The battlefield, we can't draw a line around it. Indeed, sometimes we don't know who the precise combatants are, and somebody can look like a combatant during the day is not a combatant that night, and vice versa. So 9/11 did change that, or made us more aware, I guess, of that. dynamic. And of course, we're continuing to struggle, and I think we will continue to evolve and ask these questions and try to develop legal principles that can govern these new situations. And that's been the struggle for the last decade. Well, let's see if we can do a little bit better in the second decade. Well, thank you so much for the panelists. Let's give them a hand. I want to invite everyone to return for the afternoon. We have a very fascinating discussion of U.S. foreign policy and the question of the U.S. position in the world and how that's evolved and changed since 9/11. And so that will reconvene, Jenny, at